Reich.
It's Reich, Your Honor. Good morning.
Good morning, Mr. Reich and Mr. Francino. Very good. I see you as well. Mr. Francino, say something. I know you're not on mute, but I saw your lips move.
Good morning, Your Honor.
There we go. It's working. Very good. And I understand that Ms. Colon, who is listed, is not going to be arguing, correct?
That's correct, and she is here in the virtual audience.
Very good. Then with that, you may proceed, Mr. Francino.
Thank you. May it please the court, I'm Thomas Francino. I'm the legal counsel for the clerk of the circuit court and comptroller for Collier County, Florida. We're the appellant. We seek to have reversed an order of the trial court granting a remission to a surety on a bail bond. And I'd like to save 5 minutes if I could.
Very good.
The remission order, contrary to the clear and unambiguous language of Chapter 903 Florida statutes, which controls bail bonds. And it's really a very simple case on the trial level. The operative facts are uncontroverted. There are no issues of fact. On November 28th, 2016, the defendant failed to appear for trial and a notice of forfeiture was served. And then there's two determinative facts. And again, they're not contested. On the 60th day following that notice of forfeiture was January 27th, 2017. That was a finding by the court and concession by surety's counsel. And the second determinative fact is the forfeiture was not paid until January 31st, 2017, the 64th day. And again, that's in the court order. The controlling statutory provisions are clear and unambiguous, and there's only two of those also. Section 903.26, Florida statutes, which is entitled Forfeiture of the Bond, and it provides in subsection 2A, the forfeiture shall be paid within 60 days of the notice of forfeiture. The second statutory provision is section 903.28, remission of forfeiture, and it states the court shall order remission of the forfeiture if it determines that there was no breach of the bond. The surety in this case didn't pay within 60 days and was precluded from obtaining a remission.
I have one question, because the argument that the court seemed to be persuaded by is that had the clerk obtained a judgment under 903.27, there would have been a remedy available to the bonding company to recover its funding, the surety amount. But I do have one question that nobody seems to have addressed, and maybe it's just my not reading the statute correctly, but 903.27 says if the forfeiture is not paid within the 60 days and the bond is secured other than by money and bonds authorized in 903.16. Is this a bond that's authorized under 903.16?
This is a surety bond. It's not a cash bond.
So 903, so this qualifies under 903.27.
I believe so. I wasn't, under 903.27, yes.
So 903.16 is only for cash bonds? I'm sorry, I think I said not. Yeah, 903.16.
I couldn't tell you off the top of my head, Your Honor.
Because it basically says made deposit, 903.16 made deposit with the official authorized to take bail money or non-registered bonds. Yeah. So is a surety bond not it's
not one of those two, in my opinion. It falls under the next position.
Okay. Well, that's the reason for my question is I wanted to make certain that I understood the interrelation between 903.26 and 903.27.
Well, the interrelation is that you have 60 days to pay. Upon your failure to pay, a judgment will be entered, and then the faulty logic in the trial court's opinion is that somehow that's a benefit to have that judgment entered. That's something that the surety would want. It gives them some rights. It doesn't. If you read 903.27, a judgment's entered against you. I don't know any situation where having a judgment entered is a benefit. And then it provides, if it's not paid in 10 days, notice goes out to the local law enforcement and to the state of Florida departments that supervise bonding. And after 35 days, basically the ability of the surety to engage in business is terminated. So what are the rights there? The only right is the right of any entity to ask that a judgment be set aside. And just as in a civil case, that's very, very limited, the ability to do that. It's not something someone would want to do. And I think I answered in my reply brief, there's only two bases that I could find to set aside the judgment. One was that the 60 days hadn't expired, and the court ruled that there was no judgment that was authorized and it was void. That was set aside. And the other basis is where the clerk of court does not mail out the notice of the trial or the hearing at which the defendant's required to appear. And the court says that is a condition precedent to a forfeiture. And if that doesn't...
It seems like what the trial court focused on is 903.268, which says if the defendant is arrested and returned or has posted a new bond before judgment, then the clerk shall discharge forfeiture. And it seems to me what the trial court has done is say, well, the before judgment means anytime. You know, if the clerk doesn't get a judgment after the 60 days, if it 75 days, 90 days go by and it's before judgment, then the discharge of the forfeiture means the bonding company can get its money back. And as I understand the position of the clerk, the before judgment language in 603.268 is really just designed to say that the discharge of forfeiture would happen if it's within the 60-day period before the judgment is issued.
I have several points to make on that. First of all, the surety in this case didn't ask for a discharge of the forfeiture on the 903.26. The first time that appeared is when I received an order from the trial court. So that wasn't even an issue that I was prepared for. It wasn't an issue that was asked. There wasn't a relief that was asked for.
Here's your chance to address it. The court makes reference to it, and it's referred to in the briefing. So,
in my reply,
how does the clerk interpret that before judgment language in 603.268?
I read it as at or near the expiration of the 60-day period that a judgment would be entered, and within that time period, if the defendant is brought back, then the forfeiture could be discharged without the need to file an application to the court and have a hearing by the court. Not in this case where months had gone by, and the only reason a judgment wasn't entered in this case is because they paid the forfeiture. So a judgment would never be entered in this case. And if the rule was that at any time before a judgment is entered, the defendant can be brought back, then in this case, he could have been brought back 2 years, 3 years, 5 years later, because there was never going to be a judgment entered because the forfeiture was paid on the 64th day. It would have been error for the clerk. It would have been a violation of the statute to enter a judgment when there was no debt. So it's just a faulty reading of that provision that, number one, wasn't raised in this case, and number two, can't apply if the reason that the judgment wasn't entered is because the forfeiture was paid. That does away with the time limits of the remission statute, because no longer is there a limitation of 2 years and a limitation on the amount you get back based on how long the defendant is out of the jurisdiction and makes it so that you can pay the forfeiture, judgment won't be entered, and you can come back at any time and get a full refund of the amount of the forfeiture. I don't think that's what was intended. Again, the statute's clear about having to be paid in 60 days, and the cases discussing that statute in 90328 are very clear too, that a failure to pay within that 60-day period is a breach of the bond, which precludes a remission. The second DCA in Hillsborough County case, which I cite in 2001 case, reversed an order remitting the bond. And the court pointed out that remission is a wholly statutory remedy that may not be ordered for any reason other than specified in the statute, 903.28. And that provision is in 903.287. That statute contains the only basis for a remission, not 903.268. And then in that case, even though the parties that raised the failure of the lower court to follow the statutory procedures, the second district court was troubled enough that they said, we are concerned that the procedures followed in this case did not comport with the statutory scheme requiring that a forfeiture be paid within 60 days of the date the notice was mailed. There were two other cases I cite which a remission was granted, even though there was no timely payment of the forfeiture. One's the Ramiro case, and the other is Volusia County, a 50 CA case from 1996, which the Fifth District Court of Appeals clearly held that remission under section 903.28 was not available as the surety had breached the bond by failing to pay the forfeited sum within 35 days. Of course, it was 35 days back then and not the 60 days it's been amended to now. And there's quite a few other cases. There's a handful of others I think I cite that discuss that timely payment is a prerequisite to a remission. Polikoff case, which is a 50 CA case from 2013, spells out clearly that one option of that the surety has is to timely pay forfeiture within 60 days and to apply for a remission. The Allied case, which was a third DCA case in 1982, and the court in that stated surety had 35 days to pay the forfeiture and seek remission. If surety has not paid within 35 days, no remission is authorized. Resolute Insurance case, a first DCA case from 1974. If the remission's paid in 30 days, the surety would have 11 additional months to seek remission. Those are the time limits at that point in time. So the court has completely eliminated the 60-day time limit and the requirement that there be no breach of the bond and granting remission in this. And the court cases I cite show that that time limit is a strict time limit. It can't be extended. In Hillsborough County, which I've already referenced, the trial court had granted an extension or maybe several extensions to the surety in which to declare a forfeiture. And that's where the Second District Court of Appeals says no. Chapter 903 requires that the forfeiture be paid within 60 days. County bonding case is a third District Court of Appeals case from 1990. And in that one, the trial court did grant 3 extensions to the surety to pay the forfeiture. And then they ultimately paid it. And the Court of Appeals stated that the first question raised was whether the 35-day time limit for payment could be extended. And the court said, no, the 35-day time limit cannot be extended. Chapter 903 is clear that forfeiture must be paid or discharged within 35 days. And the correct procedure was for the surety to pay the forfeiture within 35 days. And when defendant was apprehended, to seek a remission. That's a clear and unequivocal statement of the law. which the lower court here avoided. The lower court avoided it by saying the court said that there could be no extensions, but in this case, it allowed the bonding company to come back and file a motion for remission, so there really wasn't a deadline. The unique facts of that case, though, were the reason for the appellate court's ruling. The appellate court said that the surety relied upon the trial court extensions and then paid the forfeiture untimely.
Mr. Franchino, you're at the 5-minute mark if you want to reserve the rest of the 5 minutes, or you can continue.
I think I'll continue. The court said, anyway, so it's a form of detrimental reliance or justifiable reliance, plus the fact that it was I think, an initial decision on that issue. None of that applies in this case. The surety failed to pay not because it was relying on an extension granted by the court. It failed to pay due to its own fault or blame. And of course, that rule that there are no extensions possible, that's been the law now for 22 years since that county bonding decision. So the court goes on to say that 60 days does not constitute a breach if you fail to pay within the 60 days. It is only if the surety does not pay the bond at all, at any time, that there is a breach. And of course, that is a ruling that flies in the face of all of the provisions of Chapter 903. 903.26, of course, says you have 60 days to pay. 903.27 says if it's not paid within 60 days, clerk shall enter judgment. 903.28, there's no remission if there's a default. And then back to 903.27, after 10 days, there's notice given that the payment has not been made, the judgment has not been satisfied. And after 35 days, the surety loses the right to operate in the state of Florida. So obviously, those punishments or consequences are inconsistent with the trial court's ruling that a surety has unlimited time to pay the forfeiture and is only in default if it never pays. It's just an unworkable result. And then the trial court found another condition on the 60 days, and that is there had to be a judgment entered. If there was no judgment entered, I think we discussed this, then there could be no default. The judgment is not something that gives a benefit, and it's not something which extends the 60-day period. The legislature could have said must be paid within 60 days unless judgment's not entered, and a judgment's not entered until after 60 days. So I don't know how you can excuse a 60-day time limit by something that would happen after that fact. Anyway, those are the errors of law. And then finally, I want to say, I'm asking for this court to reverse, as 903.26 requires a payment within 60 days. 903.28 precludes remission if it's not paid. And this area of the law is a very confusing one. It's a very discrete one. Most attorneys and then most judges don't deal with it. And in this case, there was a order of a circuit court, the case State versus Philippe, 2015-CF-002305. It was attached to the surety's reply to the clerk's response in this matter, and it appears in the record at pages 48 through 50. And it asked the trial court to use it as authority. However, it wasn't an appellate decision. It's a trial court order. And the trial court in that case of Philippe made the same faulty conclusions of law. And unfortunately, the trial court in this case followed that roadmap and made the same faulty conclusions. And that has resulted in the decision. So I'm hoping for a clear, concise decision from this court on this issue, because I know it will continue to come up. Thank you.
Very good. Thank you very much, Mr. Franchino. Mr. Reich.
Yes, good morning. May it please the court, my counsel, Mr. Francino, Ms. Cologne, your honors. My name is Bruce Reich. I'm here on behalf of the United States Specialty Insurance Corporation. And I want to address the order that was set forth was a very detailed 6-page order that we're dealing with on the trial level. And I know the court read it, but I want to focus on perhaps the most important part of it, which was notably had the clerk entered a judgment in the case of at bar, Chapter 903 would have provided procedures by which the surety in this case would have followed to set aside the judgment in the case. And by the clerk not entering judgment, they've taken away what are statutory and rule of civil procedure remedies that are there for a purpose. I disagree with the clerk's assertion that it's a confusing body of law. These 3 statutes are really one statute.
So your position, as I understand your position, basically 603.268, where it just says before judgment, means that if a judgment is not entered, there is no time limit on the surety, the bond company, to seek refund of its funds if they're paid.
No, what I am saying is that, first of all, as we realize, this bond was paid due to a medical condition that was raised that didn't have to be litigated because we didn't get there due to an illness of the payment clerk. This was paid 2 business days late. It was never an intention not to pay it. However, what I'm saying is, if it's paid,
the statute doesn't provide for excusable neglect, though, does it? 603.28.
Well, not actually. The case authority for years states when a case is in judgment under 903.27 that upon proper filing, 1.540 does allow excusable neglect. In fact, that's been in the case law for half a century.
But nothing under 903.28.
Well, under 903.28, it doesn't have excusable neglect. However, that is irrelevant to the provisions in this case. The surety met all the conditions in this case.
Other than payment within 60 within 60 days of the notice.
Well, actually, the remission statute does not even have that payment requirement. It has a provision under subsection 1, which states that if there is no breach of the bond, the surety.
Is it a breach of the bond to not pay within the 60-day period of notice being given?
Not a breach of the bond that prevents remission relief. It is not. That language came in there by way of a stretching of the very proper decision in the Hillsborough County case, where the surety never paid at all, where the court said that, yes, we're ruling also on the merits that the surety didn't even locate or do anything to arrest the defendant. The defendant was in Mexico. But second, we're going to say you just breached it because you never even posted the money. However, this case is totally different. This is we're talking about a narrow period of time between the.
You have not cross-appealed the trial court's finding that your client was in breach of the bond, correct?
Well, I don't think the court really made a finding that we're in breach of the bond to prevent remission.
Are you sure of that? Because it seems to me that the court's order is very clear that your client breached the bond.
Well, there was no need to do that because I can tell the court right now, and I'll say it was not error for the court to make a finding that we breached the bond. What we're saying is that that's not the type of breach that prevents remission rights. It would be remiss of me to say they didn't breach. Yes, they breached the bond by not paying. However, there's nothing in the statute which calls for the extreme remedy of denying remission rights and not giving the surety rights under judgment. I want to point out,
but the remission statute says that the remission is permitted if the court determines that there was no breach of the bond. It doesn't create any exceptions. It doesn't say, well, we don't really mean breach of the bond. We really mean something else.
It does, your honors. And this wasn't brought up in Hillsborough because it wasn't relevant and they didn't have the grounds. We're not going.
But the statute, I'm talking about the statute. The statute does not carve out, does it? Where?
Yeah. Yes, under 903.28, last sentence under subsection 8. That is the language which proves the point that that breach has nothing to do with it, but shows that 903.281 is a positive catch-all remedy for non-surrender remission reliefs. that states that in cases where there's remission granted, the surety has to pay cost. I think I'm referring to the right provision at the bottom of 90328
But
subsection.
none of the other subparagraphs in 90328 would appear to apply if the court determines there's a breach of the bond.
No, it does. One is not conditioned on the other. Subsection 8 states, basically alludes that that's a separate remedy. When we look at the language, why would it be that the surety wouldn't have to pay costs if there's no breach of the bond? It wouldn't make sense. To give an example, Your Honor, if the bond was forfeited in error and there was no notice to the surety, or the bond had expired under 90331, there could be a number of reasons other than arrest or surrender to remit a bond. That is what subsection 1 was. The problem was in the Hillsborough case, it got obfuscated because those facts had nothing to do with the case at hand.
So doesn't that last sentence essentially, and I'm reading it now.
Yes.
So remission is going to be granted on the condition of payment of costs unless the ground for remission is that there was no breach of the bond.
Correct.
So it seems to me that would alleviate the bonding company's obligation to pay any other costs.
That's correct, which shows that that's obviously did not have the same meaning. The legislature intended for subsection 1, and this has not been addressed. Subsection 1 is a benefit for the surety. It's a separate and independent benefit. For instance, how would we justify in the trial level, I think it was briefed, the state of Malta case where the court granted remission essentially because there was no breach of the bond because the surety was not given pre-forfeiture notice under 903-261B. They went under what is essentially 903-281. What is the equivalent?
That was where there was a determination of no breach of the bond.
Yes, because there was no breach of the bond by the surety in that case because they didn't get notice. So we're not going
here. There's a breach of the bond by not providing the payment that's required. That's what the trial court found, and that seems to be consistent both factually and with the statutory scheme. That when you're given notice that the guy has not shown up, you've got 60 days to put the bond money into the possession of the clerk.
Well, there's a problem with the court's analysis, and I'll say why. And this is something nobody realizes. Every case that went into judgment in the history of Florida jurisprudence went into judgment under 903.27. We know that it can't go into judgment unless it's not paid or paid late. And the remedy is that a judgment is entered. And then in statute 903.271, it states when you get a judgment, if the forfeiture is not paid or discharged in that 60 days, you're now in judgment right now. And then they're giving a surety an additional 35 days to pay. They're contemplating late payment. See, that's the danger of this breach language that Your Honor's alluding to. The breach language had nothing to do with a late payment. The 903-281 breach payment is not, and it had nothing to do with late payment.
It sounds to me like your argument is one for the legislature to clear up what seems to be some ongoing confusion as to what the obligations of the surety are and what the other obligations are on the part of the clerk.
To the contrary, this legislative scheme has been there from this time of the state of Malta, which said that if the surety didn't get notice, the bond wasn't breached. For all kinds of reasons, there are remedies available that are a catch-all under 903.281. The legislature recognized, and they could have put in there, all they had to do is if the bond, they could have put under 903.26, 27 or 28, they could have enacted and said, if the bond is not paid within a 60-day time period, then 903.28 rights remission will not be available. They did not. So it's really the flip side. The court did not specifically rule. What it was is judicial interpretations, and Your Honor, I know was on the decision in Hillsborough.
I don't know, counsel. I'm just having some trouble with this because 903.262A says the forfeiture shall be paid within 60 days after the date the notice was mailed or electronically transmitted, which seems to me to be a condition specifically and directly related to the surety's obligations.
But if that's the case, Your Honor, and because I know we're not belaboring the point, if that's the case, then how do we explain Volusia versus Audette and the accredited surety decision, which says that the only reason once the case goes into judgment that you can get remission is by timely filing a motion to set aside the judgment. In other words, there's doors between the statutes. If you get the judgment set aside, then you're entitled to remission. The fact that it wasn't paid is dictum. The fact that it goes into judgment is the law. So what you're dealing with, Your Honor, is a situation.
Does 903.28 say anything about that remission if it determines there was no breach of the bond or the judgment has been discharged, the forfeiture has been discharged?
Does 903.28 state that?
I mean, it seems to me 903.28 contemplates forfeiture. It contemplates remission if there's no breach of the bond. It
Right.
doesn't say what you're arguing, which is on application within 2 years from forfeiture or upon setting aside of the forfeiture. I mean, that language isn't in 903.28.
But it doesn't have to be, because the forfeiture in this case, for instance, wouldn't be set aside. It would have been satisfied. Here, the surety paid the forfeiture. And actually, the point is there could be no judgments that could be remitted afterwards if the court's analysis would prohibit remission due to that language in 903.28 and apply that to timely payment. No judgments were timely paid. It's the untimely payment in the statute which says that it goes to judgment. It's self-evident in the statute. It contemplates that there is late payment. Ironically, Your Honor, we're here in a situation where we're alleged that there was a medical incident, that the surety who was looking for the defendant found the defendant, got the defendant rearrested, and paid the bond due to a medical incident 2 days later, is left without a remedy due to a misuse or a misapplication of the word breach as defeating a remission. Now, what had happened was, hypothetically, if the surety had not paid it, and what are we supposed to tell a bondsman? Well, you know what? You had an emergency. You didn't get this paid within the 60 days. Don't bother paying it because you're stuck. You're playing out of luck. Or are we supposed to tell a bondsman, since that happened, don't pay it because they don't put the judgment. They can't do anything to you, right? Because then the only remedy they have is putting it into judgment and cutting you off after 35 days non-payment after judgment. Don't pay it. Is that what we're trying to do? Because if the surety otherwise wait for judgment, then we're encouraging them to do the worst. Something happened medically. They couldn't pay on time on a Friday. They paid on a Tuesday. And if they were to have waited, and then the judgment came in, by the court's analysis, we'd be better off. We would have been better off not paying it, because then we have a judgment. Now we can go into 1.540. We could timely file our grounds. Grounds are not limited. 903.27 does not limit the grounds that a surety may raise to set aside a judgment. It was never the surety's intention for this to go into judgment, but they could have let it go into judgment.
Counsel, is there any limit to the argument that you're making? I mean, suppose hypothetically, the payment by the surety was made 2 weeks, 3 weeks, 4 weeks down the road before judgment was entered. Is there any limit? You're arguing that they're not entitled to remission because the judgment came after the payment. Where does that end?
Well, the question is slippery slope. If they're allowed to be 2 days late due to
isn't that the reason for the 60-day requirement? It's easy to follow. It's clearly understandable. They either have to pay within 60 days or they're not entitled.
Well,
I didn't see anything in the case law that says anything different.
No, but the case law allows under 1.540 to look at this. Give an example. If we were to wait several weeks and say we're not going to pay it, we could do a 1.54 analysis. Courts have hearings on factual issues. Was your breach material, if we go by breach, or was it an inadvertent breach? Was it a mistaken breach? Are we to punish a surety, God forbid, driving across Alligator Alley? We hear tragedies and they have that certified check in hand.
I mean, I don't see the punish the surety argument. It isn't 5 days or 10 days, it's 60 days.
No, but no, in our case,
they want to preserve their right.
No, it's our case, it's 2 days late. So
I know, but what I'm saying is that the rule is they have 60 days to pay, not 62 or 4 or 80 or 90, 60 days.
Correct.
And they didn't.
Yes.
So I don't understand why we go any further than that. They breached the bond after 60 days and the case law supports it, the rules support it.
The answer is as follows. then we would have to overturn longstanding authority in accredited surety versus state, and a case where a judgment was set aside, where forfeiture was not paid, and the judgment was set aside. In that case, there wasn't notice. It went back, and the surety had their rights to remission preserved within a year. In that case, we looked to the decisional law that's been in existence for 50 years. Remission is allowed once a judgment is set aside. That is the law. If we were to follow what is logically the court makes sense, Your Honor, makes sense that it's a strict time period. The problem in that analysis is that if that's the case, would that not undermine, and we have to look carefully, would it not undermine Volusia versus state, accredited, and every case where judgments are set aside to preserve a surety's remission rights? Would we go back and say, well, wait a minute, we set aside the judgment to preserve remission rights. We found these reasons. It could be statutory reasons, or it could be equitable reasons under 1.540, and it's set aside. That's authority. And this court relied on Volusia versus Odette in the Hillsborough case, which in turn relies on accredited versus state.
Those both involve judgments, correct?
Correct, exactly. But in one of both cases stated,
which goes back to my initial question, which is, so the way you are reading 903.26, the last portion of that in section 8, is that before judgment means that reopens the door. If the clerk delays in getting judgment, that excuses any delay in payment by the surety.
actually, I'm not saying that. What I'm saying is the legislature addressed that issue of what happens if it's not been paid and the defendant is surrendered after the 60th day, but no judgment's entered. 903.268 is a more recent amendment to the statute. What they seem to have said, knowing that we already have that statutory time period of the 30 days pre-judgment and 35 days post-judgment, that allows for an interim period that if you can still bring back the defendant and it's before judgment, we're not going to look at that time period, and you can do it before judgment or have the defendant arrested and the superseding bond, I think, filed in another jail and pay the costs. We'll let you get this set aside. So they're working, they know very well, the legislature, that this was that interim type of period of time. That doesn't justify a surety, nor would I ever recommend to a surety sit and wait, because they don't want a case to go to judgment. It's not the purpose to go to judgment. The surety did everything possible and everything right in this case, contrary to previous cases that created this misunderstanding of the law. Hillsborough was when they say bad facts make bad law makes bad precedent. That's what happened in the Hillsborough case, and as well as the Singh case, which was cited. You had two sureties that just abandoned their requirements altogether and didn't pay it whatsoever. They were sitting before the courts of appeal, before this court, and said, no, we didn't pay nothing. That's the problem when you have sureties don't follow things. This surety that paid it, that's claiming a medical emergency, is a court going to not find or have the opportunity to find a reason why there could be a medical reason? Is this one area of the law where there's no medical reason why, if it was not paid, if there's no compliance, that's a type of breach that would deny all remission rights? What type of signal would that be? So what I'm saying is that, by the way, 90326 subsection 8 that allows the clerk after the 60-day time period, but before judgment, to set it aside. The legislature spoke about that. That does not conflict with the remission timetable, because the reality is one precedes the other.
You're arguing a number of things, but are you arguing that the medical emergency is what caused the delay in payment? Is that? Oh,
no, there's no question about it. I put it in my motion.
And that should excuse the late payment?
Absolutely, absolutely, because there would be no other.
Is there any other? Can you think of any other scenario and any other rule where that's the way we analyze it? If there's a late payment, do we have to look and see whether the person who's supposed to make the payment on time had a medical issue?
Well, I cannot quote specifically other areas of the law, because I've been very, very specialized in this area of the law, so I can't come out and say.
Let's use this area of the law. Is there any other case in the surety world that talks about excusing the time requirements because of a medical issue?
No, there's none.
And we can't really run things that way, it seems to me.
Well, there's the contrary, Your Honor. The Collier County, the position of the Collier County, with all due respect to Mr. Francino, because I know he's reading it and his way is looking at it. The courts, the way they handle it, clerks of court, they have the 60-day requirement. They look at it, it hasn't been paid. The sureties come in and pay it. Some courts will say, we won't accept your money because you're beyond the 60 days. Some will say, sure, you can have more time. I'm not saying what's right or wrong. I'm explaining what really happens. Sureties could surrender the case, the bond a little later under 903.268. It's built into the system. The fact that there's no case authority doesn't reflect that there would have been a negative finding on appeal. I don't know of any other area of the law where there would be that type of draconian determination based upon a uniform reading of the word breach, because really it could be argued in this case that both parties breached. The surety breached by the defendant not showing up and they paid late. That could be argued that's a breach.
Mr. Reich, unless there is another question from the panel, that concludes your time.
Thank you. Thank you. Have a good
Very
day.
good. Mr. Franchino, I gave Mr. Reich an extra minute, so I'm going to give you 1 minute to make any final comments.
I wouldn't know where to start, Your Honor. So many issues have been raised. I would just, again, ask that it be reversed. The statutory scheme, simple. You have 60 days. If you don't pay in 60 days, it's a breach. All the cases stand for that proposition. And this shows why it's necessary to have a nice, clean appellate ruling on this issue to avoid this confusion and argument on the trial level in the future. Thank you.
Very good. Well, you knew where to begin. So you said you didn't know where to begin on rebuttal, but I appreciate the wrap up there. Both of you, thank you very much. Again, another interesting case. The next case is Ginsburg Klimt versus Lawrence Point Condominium. And for those who are waiting for the 11 o'clock docket, we will be taking a 10